I invited my daughter and her husband to a family dinner. When I checked my bank account that evening, the balance was negative $150,000. I called my daughter, but she didn't answer and was already heading to the airport. What I did next made her, "Good day, dear listeners. It's Clara again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled." People always say you don't know what you have until it's gone. I used to think that was a saying for people who lost love, or health, or youth. I never imagined it would apply to $150,000 sitting in my savings account. Money I had spent 23 years building, dollar by careful dollar. My name is Linda Mercer. At 58, I lived alone in the house I'd shared with my late husband, Robert, in a quiet neighborhood outside Phoenix, Arizona. The bougainvillea he planted along the back fence still bloomed every spring, hot pink against the bleached stucco wall. I kept it trimmed the way he liked. Some habits you don't break. After Robert passed, a heart attack 6 years ago, sudden and merciless, I threw myself into work. I ran a small event planning business out of a converted spare bedroom. Corporate luncheons, retirement parties, the occasional wedding. Nothing glamorous, but it was mine, and it was steady. I was not wealthy by any grand measure, but I was comfortable, secure. That word, secure, had meant everything to me since the day I watched them lower my husband into the ground and understood that I was entirely on my own. My daughter, Ashley, was 31. She had her father's blue eyes and, as it turned out, very little of his honesty. I had loved her with the particular fierceness of a mother who has already lost one person she cannot replace. I forgave her things I shouldn't have. I looked away from things I shouldn't have ignored. She had married Derek Holt 3 years earlier at a ceremony I paid for. Derek was charming the way certain men are charming, effortlessly and with purpose. He sold commercial insurance, drove a lease car that was always one model too expensive, and had opinions about wine that he delivered with the confidence of someone who had read 2 articles on the subject. Robert would have seen through him in 10 minutes. I told myself I was being unfair. The first signal came 8 months before everything collapsed. Ashley called me on a Tuesday evening, casual, almost rehearsed in its casualness, and asked whether I had ever thought about consolidating my finances. She used that word, consolidating. I remember thinking it was an odd word for a daughter to use with her mother. "Derek has some contacts," she said, "financial advisors, people who get better returns than whatever your bank is giving you." I told her I was happy with my bank. She didn't push. But something about the conversation sat in my stomach the wrong way, a small stone I couldn't dislodge. The second signal came 2 months later. Derek asked me, during a Sunday lunch at their apartment, whether I still had that power of attorney document, the one I had signed years ago, when Robert first got sick, and we needed someone to manage accounts if things got bad. I had listed Ashley as my agent. It had seemed responsible at the time. The document was still valid. I had simply never thought about it again. "Just making sure it's current," Derek said, cutting into his steak with the focused attention of a man who was not actually thinking about steak. I said yes, it was current. He nodded and changed the subject to the Cardinals game. I changed the subject with him. Looking back, I understand now that both of those conversations were reconnaissance. He was mapping the territory before he moved. The evening it happened, I had spent the afternoon in my kitchen making the pot roast Ashley had loved since childhood. I set the table with the good cloth napkins, the ones I only used for family. I had even bought a bottle of the Cabernet Derek always praised, though I normally drank it only on holidays. They arrived at 6:30. Derek complimented the house. Ashley hugged me a beat too long, the way she sometimes did when something was wrong, though I told myself I was imagining it. We ate. We talked about nothing in particular. Their neighbor's new dog, a trip they were supposedly planning to Portugal. Derek had a second glass of wine. Everything was normal. Everything was warm and ordinary and entirely false. They left at 9. I washed the dishes, poured myself the last inch of wine, and sat down at the kitchen table with my phone, the way I did most evenings, to check my accounts before bed. A routine. 30 seconds. No more. The number on the screen didn't register at first. My brain refused it the way the body refuses a sudden cold, a full second delay before the shock arrives. $150,000. I read it 3 times. I set the phone down. I picked it up again. The number did not change. My hands were steady, which surprised me. I called Ashley. It rang 4 times and went to voicemail. I called again. Voicemail. I sent a text. Ashley, call me right now. Something is wrong with my account. 3 minutes later, a reply came through. Not a call, a text. We're on our way to the airport, Mom. Talk tomorrow. I stood in my kitchen, in the house where I had raised her, surrounded by the smell of the dinner I had cooked for her, and I understood, with the slow, terrible clarity of a woman who has already survived one catastrophic loss, that tomorrow would be too late. I did not sleep that night. I sat at the kitchen table until the bougainvillea outside went from pink to gray to pink again, and I went through every document I could find in the house, spreading them across the tablecloth still faintly stained from the pot roast. Bank statements. Tax returns. The power of attorney, which I eventually found in a manila folder in the filing cabinet in Robert's old study, behind the car insurance papers. I read it twice. It was a general durable power of attorney, signed in 2017, notarized, entirely valid. It named Ashley Christine Mercer, now Holt, as my agent with broad authority over financial accounts. At the time, my attorney had called it a just-in-case document. He had meant, just in case you become incapacitated. He had not meant, just in case your son-in-law decides your savings account is a personal fund. I called the bank at 8 a.m. the moment they opened. I was transferred 3 times before I reached someone in the fraud department, a woman named Carol, who had the careful, practiced voice of someone trained to deliver bad news without triggering hysteria. The transfer was authorized, Carol said. It was processed using a valid power of attorney. The account holder, that's you, Mrs. Mercer, had a named agent on file, and the agent initiated a wire transfer yesterday at 2:47 p.m. 2:47. I had been at the grocery store at 2:47. I had been buying the wine I served them at dinner. The transfer went to an account ending in 7741, Carol continued. We can flag the account and open an investigation, but I have to be honest with you. When a valid POA is used, recovery is complicated. It's not the same as fraud in the traditional sense. My daughter didn't steal from me, I said, and then stopped, because the sentence had come out wrong. I had meant to say someone stole from me. What I had actually said was that my daughter hadn't done it, and I wasn't sure that was true. I wrote down everything Carol told me. Account number, transfer time, reference code. The name of the fraud department supervisor. I underlined the reference code twice. After I hung up, I sat very still for a moment. The fear was physical. I want to be precise about this because people use the word fear loosely. This was not anxiety, not worry, not the low hum of general dread. This was a cold weight in my chest, a faint shaking in my fingers, a strange ringing in my ears that I associated afterward with the sound of 23 years of work being erased in a single afternoon. I had $4,200 in a checking account and some equity in the house. That was what I had left. And then something shifted. I have thought about this moment many times since. I cannot fully explain it, except to say that I have already survived the unsurvivable once. I buried my husband. I rebuilt my life from a foundation of grief and stubbornness and very good bookkeeping. I was not going to sit in my kitchen and cry over two people who had eaten my pot roast and wired my money to an account ending in 7741 before their plates were cold. I got up. I made coffee. I found a legal pad. The first thing I wrote was, "What do I know for certain?" I knew the transfer had been made using the power of attorney. I knew it had been processed at 2:47 p.m. on the day of the dinner. I knew Ashley had not answered 2 phone calls after the fact. I knew Derek had asked about the POA 2 months earlier, casually, over steak. The second thing I wrote was, "What do I need?" I needed a lawyer. Specifically, an attorney who handled financial elder abuse cases, because that was almost certainly what this was. I needed to revoke the power of attorney immediately. I needed documentation of everything: the transfer record, the phone records, the text message Ashley had sent me, any financial correspondence I could locate. And I needed to understand precisely where that money had gone. The third thing I wrote was, what is their next move? This was the question that focused me more than anything else. Derek was not stupid. He had planned this carefully: the timing, the dinner, the head start to the airport. He would expect me to be devastated. He would expect a grieving mother who loved her daughter too much to pick up the phone and call the police. He would expect me to call Ashley again and again and leave messages that grew more desperate and pleading until eventually he was ready to answer. He had misjudged me. I had been married to a man I loved for 27 years. I had watched him get sick, and I had managed his care, his accounts, his insurance claims, and his final arrangements, and I had done it all without falling apart in any way that mattered. Grief had not broken me. Derek Holt was not going to break me either. I picked up the phone and called Margaret Osei. Margaret was a family law and estate attorney. I had met 6 years earlier when I needed help settling Robert's estate. She was 62, Nigerian American, with reading glasses she wore on a beaded chain and a manner that made juries and opposing counsel equally uncomfortable. She had given me her direct number after the estate was settled and told me to call if I ever needed her. "Margaret," I said when she answered, "I need an emergency appointment. Today, if possible." A pause. How bad? $150,000 bad. Another pause, shorter. "I have a cancellation at 11. Can you be here at 10:45? I was there at 10:30. Margaret's office was on the 14th floor of a building downtown that smelled of recycled air and carpet cleaner. Her assistant, a quiet young man named Paul, brought me water without being asked, which I appreciated more than I could have explained at that moment. Margaret listened without interrupting. She had a yellow legal pad in front of her and a pen she held but didn't use until I finished speaking. Then she wrote 4 words and turned the pad to show me. POA. Transfer. Timing. Intent. "The good news," she said, "is that a power of attorney does not give an agent unlimited license. It creates a fiduciary duty. The agent, your daughter or whoever acted in her name, is legally required to act in your interest, not theirs. Transferring $150,000 to an outside account without your knowledge or consent almost certainly violates that duty." "Is that criminal?" I asked. "It can be. In Arizona, financial exploitation of a vulnerable adult is a Class 4 felony. Now, She held up a hand before I could speak. The statute is typically applied to adults over 65, or those with documented cognitive impairment. You are 58 and clearly competent. That changes the landscape slightly, but we are not without options. We can pursue civil recovery and, depending on what law enforcement finds, potentially criminal charges through the DA's office. She walked me through the steps in order. First, revoke the power of attorney immediately, in writing, notarized, filed with the county recorder's office, and sent certified mail to Ashley. Second, send a formal legal demand letter to Ashley and Derek, requiring return of the funds within 10 business days. Third, file a police report. Not because the police would necessarily recover the money, but because the report created an official record and opened the door to a criminal investigation. Fourth, contact the receiving bank with a subpoena request to identify the account holder on the other end of the transfer. Who owns account 7741? I asked. That, Margaret said, is exactly the right question. I left her office at 12:30 with a folder of documents and a weight on my chest that was different from the morning's weight. Heavier in some ways, but load-bearing. Something to push against. I filed the police report that afternoon at the Maricopa County Sheriff's Office. The deputy who took my statement was a young woman named Officer Tran, who wrote everything down with the focused efficiency of someone who had taken these statements before. Financial disputes between family members, she told me carefully, were complex, but the POA usage and the amount made it worth flagging for a detective. What I did not know, as I sat in that beige-walled room going through my timeline, was that Ashley had already called the bank. I found this out 2 days later from Carol in the fraud department, who had by that point become something of an unlikely ally. Carol called me, slightly outside the bounds of normal procedure, I think, to let me know that someone using Ashley's name had contacted the bank asking about the status of the POA and whether any flags had been placed on the account. She knows, I said. It seems that way, Carol said. That evening, Ashley called me for the first time since the dinner. I let it ring. I was not ready. I needed to know more before I spoke to her, because the moment I spoke to her, Derek would know exactly where I was in the process. The proof came on a Thursday, 9 days after the dinner, in the form of a document that Margaret's paralegal retrieved via a formal records request to the Arizona Secretary of State's office. 3 months before the transfer, Derek Holt had registered a limited liability company, Meridian Capital Consultants, LLC. The registered address was a mailbox at a UPS store in Tempe. The single listed member was Derek Andrew Holt. The account ending in 7741 belonged to Meridian Capital Consultants, LLC. My money had not gone to pay off a debt or cover a medical emergency or fund some misguided investment in Ashley's name. It had been transferred with deliberate premeditation into a company Derek had created specifically to receive it. The dinner, the wine, the hug that lasted a beat too long, all of it had been window dressing around a theft that he had been planning for at least 3 months. I sat in Margaret's conference room and looked at the Secretary of State document for a long time. This is the proof, Margaret said quietly. She didn't phrase it as a question. Yes, I said, this is the proof. My hands were not shaking. I want to note that. Whatever I had been in the first hours after I saw that bank balance, I was not that anymore. Something had settled in me. Not anger exactly, though the anger was there underneath, clean and cold. Something more like clarity. The kind of clarity that comes when you finally stop hoping you were wrong about something. I had not been wrong. The demand letter went out by certified mail and email on a Friday morning. Margaret had written it in the precise, unembellished language of someone who has spent decades saying serious things and intending every word. It named Ashley Christine Holt and Derek Andrew Holt. It referenced the wire transfer of $150,000 on the specific date and time. It cited the fiduciary duty created by the power of attorney, the Arizona revised statutes, and the existence of the police report case number. It demanded return of the full amount within 10 business days, failing which Margaret's office would file a civil complaint and forward the complete file to the Maricopa County Attorney's Office for criminal review. I spent the weekend that followed doing normal things with the focused deliberateness of someone who understands that normal things are a form of armor. I walked in the morning. I watered Robert's bougainvillea. I returned phone calls from clients about 2 upcoming corporate events and handled them professionally, because my business was the one remaining financial structure I had, and I intended to protect it. The call came on Monday, not from Ashley, from Derek. He didn't shout, which I had half expected. His voice was controlled, almost pleasant, which was worse. "Linda," he said, as though we were old friends, "I think there's been a misunderstanding." "Has there?" I said. I was standing in my kitchen. I had my phone in one hand, and I was gripping the edge of the counter with the other, not from fear, but from the conscious effort to stay very still. "The transfer was an investment arrangement. Ashley and I discussed it with you at dinner. You agreed to let us manage some of your funds." "I did not, and we fully intend to return a profit. This legal letter is completely unnecessary and, frankly, hurtful. We're family, Linda." The word family landed in a specific way. I had suspected he would use it. People who steal from family always invoke the word family when they are caught. It is the last argument they have. "The letter came from my attorney," I said. "Any response should go to her office." A pause. The pleasantness evaporated. "You don't want to do this," he said. "I'm telling you as someone who genuinely cares about your well-being. Ashley is devastated. You're going to destroy your relationship with your daughter over a misunderstanding, and you're going to embarrass yourself when this gets thrown out." "Then let it get thrown out," I said, "in court." Another pause, longer. Then, "You should think very carefully about who your friends are in this situation, Linda. Not everything is black and white." It was not quite a threat. It was carefully constructed to not be quite a threat. I recognized the architecture of it. "I'll pass that along to my attorney," I said, and hung up. I stood in the kitchen for 30 seconds, breathing evenly. Then I called Margaret and gave her a word-for-word account of the conversation, which she noted and added to the file. The direct threat came 4 days later. Ashley showed up at my house in the evening, without calling, without warning. And when I answered the door, her face was something I had not seen before. Not the daughter I remembered. Something harder and more desperate underneath, like a mask that had been on too long. "You're going to ruin us," she said. She was not crying. She had moved past crying to somewhere colder. "Derek says if you go through with this, he'll tell everyone about the loan." I didn't move from the doorway. "What loan?" "The money you lent him 2 years ago. $20,000. He says he'll tell the court you gave it to him willingly, that you've been giving us money for years, and that this was another gift that you're now pretending was a theft because you regret it." I looked at my daughter for a long moment. The $20,000 she was referring to was money I had given her, not Derek, when they were behind on rent in 2022. I had given it as a gift, not a loan. I had no documentation of any loan to Derek because there had been no loan to Derek. "That would be perjury," I said. Something moved across her face, a flicker. "He said you'd say that," she said quietly. Go home, Ashley. My voice did not waver. Tell Derek my attorney will be in touch. I closed the door. I leaned against it in the hallway in the dark and allowed myself 30 seconds of feeling the full weight of what that conversation had been. My daughter had come to my door to threaten me on behalf of her husband. Whether she understood what she was doing or had been told what to say, the result was the same. After 30 seconds, I pushed off the wall and went to pour a glass of water. 3 days later, I drove to Sedona by myself. I stayed in a small inn I had visited once with Robert, in the Red Rock Canyon, where the light in the evening turns everything gold. I slept, properly, for the first time in 2 weeks. I walked in the mornings and ate dinner alone and did not check my legal email. I read a novel. I watched a storm come in over the mesas from the porch of my room and felt, for the first time since the bank statement, something that was not fear and not rage. It was patience. The particular patience of someone who has already made their decision. I came back from Sedona on a Sunday evening. The house looked the same. The bougainvillea had lost a few blossoms in the wind, which I swept from the walkway before I went inside. The message from Derek was waiting in my email inbox. Sent Saturday afternoon, so I would find it on my return. He had written it carefully. I could see the construction in every sentence, the practiced balance of concession and manipulation. He acknowledged that the situation had escalated in ways none of us wanted. He said Ashley was struggling enormously with the rift between us. He said he had consulted with his own financial advisor and believed a reasonable resolution was available to everyone involved. He was proposing to return $80,000. He called it a settlement in good faith. In exchange, he wanted me to withdraw the police report, release him and Ashley from any civil liability, and sign a document stating that the original transfer had been a mutually agreed investment arrangement. In other words, take back slightly more than half of what he stole, lie under oath about the rest, and hand him a signed document that could be used against me forever. I read the email twice. I forwarded it to Margaret without comment. She called me 20 minutes later. He just confessed, she said. That's what I thought. A legitimate transaction doesn't require a settlement. The offer to return $80,000 is an explicit acknowledgement that money changed hands and that he is unwilling to justify the full amount. His attorney, if he has one, should have told him not to send this. Does he have one? I'm not sure he does, Margaret said, which tells me something. It told me something too. Derek was operating on confidence. The confidence of a man who had done this before, or who believed he was smarter than the situation required. He had planned the theft carefully, but was improvising the aftermath. That gap between planning and improvisation was exactly where people like him made their critical mistakes. I sent the email reply myself, with Margaret's language. Mrs. Mercer has received your proposal and declines. All communications should be directed to her legal counsel. 2 days later, Ashley called again. This time I answered, because Margaret had advised me to maintain a record of direct conversations. Ashley's voice was different from the night she had come to the door. Softer. More like the daughter I recognized. Mom, she said, I just want to talk. Just us. Can we please just talk? And I felt it. Of course I felt it. I am a mother. The pull toward that voice existed entirely independently of everything I knew to be true. That is the particular cruelty of this kind of situation. The person used against you is also a person you love, and those two facts do not cancel each other out. I'm listening, I said. I know what Derek did was wrong, she said. And there it was. The thing I had been waiting to hear from her, the sliver of truth. I know it. But if you take this to court, if this becomes criminal, her voice broke in a way that sounded real. He goes to prison, Mom, and I have nothing. I have no job, no savings, I'll lose the apartment. You'll destroy my life trying to hurt him. I sat with that for a moment. Ashley, I said carefully, the money he took was my retirement. It was everything I had outside of this house. Did you think about my life when you drove to the airport? Silence. I want you to be safe, I said. I genuinely do. But what you're describing isn't a reason for me to let this go. It's a reason for you to get a very good divorce attorney. She hung up. It had not been a real conversation. It had been a strategy. The maternal angle. The appeal to my instinct to protect her, even at my own expense. I didn't blame her for trying. I think she may have even half believed it herself, which made it both more and less effective. What I needed now was not strategy. What I needed was people who would simply stand with me without an agenda. I called my friend Patricia Bellows, who had been my closest friend for 20 years and who had the distinction, rare among people I knew, of saying exactly what she thought without embellishment. I told her everything over coffee at her kitchen table, and she listened with the still, focused attention of someone who understands that what is needed in that moment is not advice, but presence. "What do you need from me?" she asked when I finished. "Right now, just this," I said. She nodded. She refilled my coffee. She asked about the Sedona trip, and I told her about the storm over the mesas. And we talked for another hour about things that had nothing to do with Derek Holt. And by the time I drove home, the weight was not gone, but it was distributed differently. Shared weight, which is the only kind that becomes bearable. I also called my accountant, a methodical man named Stan, who I had worked with for 15 years, and asked him to audit my business accounts independently, as a precaution. Stan called back 2 days later to confirm that my business accounts were clean. Derek had only accessed the personal savings via the POA, which he had not had any authority to apply to the business structure. The investigation was moving forward. Margaret had received a response from the receiving bank confirming that a subpoena was being processed for the Meridian Capital Consultants LLC account records. The detective assigned to my case, a deliberate, careful man named Detective Arroyo, had called to tell me they had confirmed the LLC registration and the transfer timeline and were building a case file. Slowly, methodically, the net was tightening. Derek and Ashley were watching. I could feel it, the silence from their end, the way the calls had stopped after Ashley's last attempt. They were recalibrating, trying to figure out how far I intended to take this, whether I would still blink. I would not blink. They came on a Wednesday evening, 3 weeks after Sedona. I had not been warned. No call, no text. At 7:15, my doorbell rang, and when I opened it, they were both there. Ashley in a coat I hadn't seen before, Derek with his hands in his jacket pockets, and that particular expression of his, the one that had taken me 3 years to correctly identify as not warmth, but the performance of warmth. I did not open the storm door. "We wanted to talk to you in person," Ashley said. "Please, Mom, 5 minutes." What do you do when your daughter is standing on your porch? You do not simply close the door, not if you are still a human being and not merely a legal proceeding. I stepped back and let them in, but I did not offer them seats, and I did not move toward the kitchen. We stood in the front hallway, the three of us, as though none of us intended to stay. Derek began. He had prepared, I could tell. The pacing of it, the way he leaned back slightly on his heels as he spoke, feigning ease. He was sorry. The word came out smoothly, without friction. He and Ashley had been under enormous financial pressure, a debt to a private investor that had come due unexpectedly, and he had panicked and acted rashly, and he understood that what he had done was wrong. He wanted to make it right. He used the word family 4 times in 3 minutes. I counted. "I know you're angry," he said. I understand. But if we can come to an arrangement between ourselves, keep this private the way families handle things, everyone comes out better. The alternative is lawyers and courts and the kind of public ugliness that doesn't benefit anyone. He paused, and his eyes settled on me with something that was not quite a smile. Including you, he said. A legal battle is expensive, Linda, even when you win, and you're running a small business and things are already tight. My finances are not your concern, I said. I'm just pointing out, he continued as if I hadn't spoken, that a pragmatic solution, a structured repayment, 80,000 now, the rest over 18 months, keeps this from becoming something no one can control. The moment it goes fully criminal, it's out of all our hands. Ashley could be called as a witness. Things she said to you, things she knew, those become part of a record. Do you understand what I'm saying? I understood exactly what he was saying. He was telling me that if I proceeded, he would implicate Ashley, whether as a co-defendant or as a witness forced to testify against her own interests. He was using her as a buffer. And the terrible thing was that there was a thread of truth in it. Ashley had known. How much she had known and when was something the investigation would determine. But she had stood on my porch and delivered his message and driven to the airport without calling me. Her involvement was real. He was betting I would not risk her. I looked at Ashley. She was not looking at me. She was looking at the floor, at a point near the baseboard, and her jaw was set in a way that told me the performance of the apology had cost her something. She was ashamed. That was real too. But shame, in this case, was not the same as innocence. Derek, I said, you premeditated this. You registered that LLC 3 months before the transfer. You asked me about the power of attorney 2 months before. You came to my dinner table and ate my food and thanked me for the wine, and then drove to the airport with my retirement savings in an account registered to a mailbox at a UPS store. There is no version of this conversation in which I don't know that. Something changed in his face. The ease went out of it. You're making a mistake, he said. The pleasantness was gone now, fully. This was the version of Derek that had been underneath the whole time. I've made mistakes, I said. Signing a power of attorney without a sunset clause was a mistake. Trusting you with my daughter was a mistake. Serving you dinner was a mistake. But going to my attorney on Monday morning was not a mistake. Calling the police was not a mistake. And asking you to leave my home right now is not a mistake. Ashley made a sound. Not quite a word. She reached out and touched Derek's arm, and the gesture frightened me slightly. Not because it was violent, but because it was automatic. The reflex of a woman who had reorganized herself around this man. Derek straightened. You'll regret this, he said. Flat. Final. Perhaps, I said. I opened the front door. Good night. They left. I watched the headlights of Derek's car disappear around the corner, and then I closed the door and stood in the hallway in the silence. I was afraid. I want to be accurate about this. The threat in his last words had been real, and I was not naive enough to dismiss it. Derek was a man who had planned a theft over 3 months and executed it at a dinner table. He was capable of sustained, purposeful action. I did not know what form his retaliation might take, but the fear did something unexpected. It did not loosen my resolve. It sharpened it. Because fear, I had learned once before in my life, is only dangerous when it makes you stop. When you keep moving through it, it becomes something else, a form of fuel, cold and efficient. I went to the kitchen, wrote down everything that had been said in that hallway, time-stamped it, and emailed it to Margaret at 9:47 p.m. Then I went to bed, and I slept. The civil hearing was scheduled for a Tuesday in November, 4 months after the dinner. It was not a criminal trial. That process was slower, and Detective Arroyo's file was still moving through the Maricopa County Attorney's Office. What Margaret had filed was a civil complaint for breach of fiduciary duty, unjust enrichment, and fraud, seeking full restitution of $150,000 plus legal fees and punitive damages. Derek had, at some point in the preceding weeks, retained an attorney, a man named Ferris who wore good suits and had the particular over-prepared energy of someone who had been handed a weak case and told to do his best with it. I arrived at the courthouse at 8:30 in a gray blazer I had owned for 12 years and a pair of reading glasses Robert had always said made me look formidable. Patricia drove me. She waited in the hall. I had not slept especially well the night before, but I had slept, which felt under the circumstances like a small act of defiance. Derek and Ashley came in together, 5 minutes before the scheduled time. Ashley had her hair pulled back. She didn't look at me. Derek looked at me once, quickly, and then looked away. The involuntary tell of a man reassessing odds. His suit was pressed. His posture was composed. But his jaw was set in a way I recognized as effort, not ease. The judge was a woman in her mid-60s, Judge Eileen Park, with reading glasses on a chain, and the focused patience of someone who had heard every variety of human dishonesty across a long career and was no longer surprised by any of it. She ran a quiet courtroom. Margaret had structured our presentation in 4 parts: the POA and its limitations, the evidence of premeditation, specifically the LLC registration 3 months prior, the transfer record, and Derek's own email offering to return $80,000, which Margaret correctly characterized as an admission. Ferris's strategy became apparent within the first 20 minutes. He argued that the transfer had been a voluntary investment decision made with Linda's knowledge and consent, that the dinner conversation had constituted an oral agreement, and that the subsequent legal action was a family dispute being mischaracterized as fraud due to a breakdown in the personal relationship. Judge Park listened to this with an expression that gave nothing away. Then came the cross-examination. Margaret asked Derek to explain, in his own words, when he had first conceived of the idea of Meridian Capital Consultants, LLC. He said it had been formed in response to an existing business opportunity that had presented itself around that time. Margaret asked him to name the business opportunity. He said it was a real estate investment vehicle. She asked him to name the property or properties involved. He paused. He said the deal had fallen through subsequently. She asked him why, if the investment had fallen through, the $150,000 remained in the Meridian account rather than being returned. He said the funds were being held in preparation for the next opportunity. Margaret placed the bank records for Meridian Capital Consultants on the screen. The $150,000 had been transferred out of the Meridian account within 11 days of its arrival, moved to a second account, the ownership of which the subpoena had revealed to be a trust registered in Nevada, with Derek Holt listed as the trust's sole beneficiary. The courtroom was very quiet. "Mr. Holt," Margaret said, "you testified that the funds were being held in the Meridian account in preparation for a future investment." "Yes," he said. "The records show the funds left the Meridian account 11 days after the transfer. Can you explain where they went?" Ferris objected. Judge Park overruled him with a single word. Derek said the funds had been transferred for security purposes. Margaret asked him to define security purposes in relation to a trust of which he was the sole beneficiary. He said it was standard financial practice. She asked if he could produce any documentation of the investment for which these funds had been held. He said documentation was being compiled. Ferris interjected again, citing relevance. Judge Park looked at him over her reading glasses for a moment, that lasted slightly longer than necessary, and said nothing. Ferris sat back down. It was at this moment that I understood, watching Derek from across the courtroom, that he had not expected to be here. He had expected the dinner, the airport, a few desperate phone calls from his mother-in-law, and then either silence or a quiet settlement. He had not expected a woman who filed a police report the morning after and hired Margaret Osei. He had not expected bank subpoenas or LLC registration records or a Nevada trust traced back to his name. He had expected grief to do his work for him, and it had not. The contradiction he had walked into was inescapable. He had told the court the money was in Meridian. The bank records showed it had already moved. He had told the court the transfer was a consensual investment. Margaret had the LLC registration showing premeditation. He had told the court there was an oral agreement at dinner. I took the stand and stated, clearly and without hesitation, that no such conversation had occurred, that I had served pot roast and Cabernet and spoken about a neighbor's dog, and that the subject of investment arrangements had not come up. Margaret introduced my phone records showing I had called Ashley twice from the kitchen table the same evening. Not the calls of a woman who had just agreed to wire her retirement savings, but the calls of a woman who had discovered it missing. Ashley was called to testify. She sat in the witness chair with her hands folded in her lap, and she did not look at Derek, and she did not look at me. She looked at the space between us. Her breathing was visible, shallow, controlled, the breathing of someone holding themselves together through an act of sustained will. And when Margaret asked her whether she had, at any point, discussed with her mother a plan to transfer $150,000 to Derek's investment company, Ashley was silent for 4 seconds that felt very long. "No," she said finally. "We didn't discuss it." Ferris's pen went still. Derek's face did something I had never seen it do. It fractured, just briefly, just for a moment, a crack in the performance that showed the raw calculation underneath. He had counted on Ashley. She had just removed the only piece of his defense that could not be disproved by a document. In that single syllable, no, she had chosen something. I don't know what it cost her. I know it was real. Judge Park took a 20-minute recess. When she returned, her expression was the same as it had been all morning, but something in the courtroom had shifted entirely. The architecture of Derek's story had collapsed, quietly and completely, under the weight of its own contradictions. Judge Park's ruling came 12 days after the hearing, in a written decision that Margaret read to me over the phone, in a voice that was professionally measured but not entirely neutral. The court found in favor of Linda Mercer on all 3 counts. On the breach of fiduciary duty, the evidence established clearly that Derek Holt, acting under the power of attorney as Ashley Holt's designee, had transferred funds for his own benefit in direct violation of his agent's legal obligation to act in the principal's interest. The LLC registration predating the transfer was cited as evidence of premeditation. The rapid movement of funds to the Nevada Trust was cited as evidence of intent to conceal. On unjust enrichment, the full $150,000 was ordered returned. On fraud, the court found that the oral agreement defense was unsupported by any evidence and contradicted by the testimony of both Linda Mercer and, critically, Ashley Holt. Punitive damages of $45,000 were awarded, in addition to restitution, reflecting the deliberate and premeditated nature of the conduct. Total judgment, $195,000, plus legal fees. Derek had 30 days to comply or face asset seizure. I sat with my phone in my hand after Margaret finished reading, in the kitchen where I had eaten alone the morning after the dinner, and made my list on a yellow legal pad. And I felt something that I did not immediately have a name for. It was not triumph, exactly. It was quieter than that. It was the particular feeling of having done the necessary thing completely and arrived at the other side of it. I set the phone down on the table and looked at the window, at the ordinary gray morning outside, and understood that it was over. The asset seizure became necessary. Derek did not comply within the 30 days. He didn't have $195,000 in accessible accounts. The Nevada Trust was the subject of a separate legal action, still moving. And Ferris had, at some point, apparently withdrawn from the case, which told its own story about how his legal fees had been going. Margaret filed for judgment enforcement. The court authorized a lien on the Holtz apartment and an attachment order on Derek's income. His employer, the commercial insurance firm, received formal notification of the garnishment. Within 6 weeks of that notification, Derek was let go from his job. His employer, it emerged, had a conduct clause in employment contracts regarding financial fraud judgments. The provision was standard in the industry. Derek had apparently never imagined it would apply to him. The lease on the car was terminated when the garnishment hit his accounts. The vehicle was collected from the parking garage of the apartment building on a Thursday morning, which 2 of their neighbors witnessed. The apartment, which had been in both their names, went up for sale under the lien within the month. The criminal case moved more slowly, as criminal cases do, but it moved. Detective Arroyo called me in January to inform me that the Maricopa County Attorney's Office had filed charges. 1 count of theft by misappropriation, 1 count of fraudulent use of a power of attorney. Class 4 felony charges, both. Derek's arraignment was scheduled for March. Ferris was not representing him. The public defender's office had assigned someone new. Ashley was not charged. The evidence of her direct involvement did not rise to the standard required for criminal prosecution. She had known, but knowing is not always participating. Her testimony at the civil hearing, when she told the truth under oath, had been noted by the county attorney's office and had effectively confirmed her as a cooperating witness rather than a co-defendant. I did not know then how much that decision had cost her. Whether Derek had threatened her, whether she had simply found in that courtroom some version of herself that she recognized and could not betray. I did not ask. Some things you accept as fact without requiring the full account. I called her 2 weeks after the civil judgment. She answered on the second ring. "I don't know what I can say to you," she said. She sounded like herself, not the voice from the porch, not the voice from the phone call about Derek going to prison. Her own voice, stripped of performance. "You told the truth," I said. "That's what you can say." A long silence stretched between us, across whatever distance she was calling from, and I let it sit. "I didn't know about the LLC," she said finally. "I knew he wanted to borrow money. I knew he was going to ask you. I didn't know he'd already." She stopped. "I should have asked more questions. I should have called you from the airport." I thought about that for a moment. About the airport, the dinner, the wine, the hug that had lasted a beat too long. "Yes," I said, "you should have. We didn't reconcile that day. We didn't pretend that a 2-minute phone call could repair what had been broken. But a door had opened. Narrow, uncertain, with a great deal of difficult work on the other side of it. I chose to leave it open for my own sake as much as hers. The full restitution, drawn from the enforcement actions and a partial liquidation of the Nevada Trust Margaret's colleagues had managed to attach, cleared in April. $195,000 plus $18,000 in legal fees. Every cent returned to the account I had spent 23 years building in the bank where I had kept it since Robert and I were young. I stood at the kitchen table on the morning the wire confirmation came through and looked at the balance on my phone screen for the second time in less than a year. The number was right. I put the phone face down on the table, finished my coffee, and went outside to water the bougainvillea. Spring came late that year, or perhaps I simply noticed it more than usual. I had the bougainvillea pruned properly, and it came back fuller than it had been in years. I repainted the front door a deep terracotta, a color I had wanted since I moved in and always put off. Small things. But small things, I had learned, are how you rebuild. You do not reconstruct a life in one dramatic gesture. You do it one door at a time. Professionally, the year after the trial turned out to be my strongest in a decade. A former client referred me to a regional hotel group seeking a long-term event coordination contract. Steady, recurring work I had never had access to before. I hired an assistant named Diane, efficient and good-humored. I had money, actual money, and the knowledge of exactly what it had cost to earn it. I traveled. Back to Sedona twice. Once alone, once with Patricia. I went to Boston for a conference and stood in a hotel ballroom overlooking the harbor and felt something that was not surviving anymore. It was simply living. Derek's life had organized itself into diminishing returns. The commercial insurance industry was not large, and fraud judgments follow people. He had not found comparable work. He was renting a room in Mesa. Not an apartment, a room. I did not take pleasure in this, but I did not grieve it either. Ashley had moved out before the lien forced the apartment sale. She was living with a college friend, working at a marketing firm, paying her own rent. We had spoken 4 times since the judgment. Never long, never easy, but real. She had started seeing a therapist. I received that without comment, though it meant something to me. I did not know if we would find our way back to each other. But the wanting was still there. The particular, unkillable wanting of a mother for her child. The version of Ashley who had told the truth on the witness stand was the person she was still capable of being. That was enough to work with. The summer evening I sat on the back porch and watched the light fade from the bougainvillea, deep pink to rose to gray. I thought about Robert and what he would have recognized. That there are losses you absorb and losses you refuse, and the wisdom is knowing which is which. The stars came out over the Arizona desert, and I sat with my coffee and the quiet and the long, uncomplicated pleasure of having landed on the right side of something. They say blood is thicker than water. Maybe. But it does not make theft into a gift or a signature on a document into permission to take everything you have built. I signed a piece of paper because I trusted. I lost $150,000 because I looked away from the signals, and I got it back. Every dollar. Because I stopped waiting to be wrong about what I already knew. Document everything. Trust carefully. Act quickly. What would you have done? Answered that last phone call from the airport, or let it ring? Leave a comment below. And thank you, truly, for listening.